After knowing the definition of employer and employee, our next topic would be the determination of the relationship existing between the two. When can we say that there is employer-employee relationship? The Supreme Court, through jurisprudence, came up with the famous four-fold test. There is no basis here, and if you look at the labor code, because there's no provision outlining the four-fold test. It is only found in jurisprudence. As we all know, the jurisprudence or the decisions of the Supreme Court form part of the law of the land because they are interpretations of the law, interpretations of legal principles. That is found in Article 8 of the Civil Code. So what's the meaning of this test? Before going to that, I would like to emphasize again that we have to know and determine the existence of employer-employee relationship. Otherwise, the labor code will not apply. Now, to recapitulate, you all know that the fourfold test contains the following: the right to hire, the payment of wages, the power of dismissal, and the power of control. According to the Supreme Court, the most important among the four is the power of control. What do you mean by control? So there is control when the employer or entity exercises power and determines how the manner or the means or how the work will be conducted, the procedure on how the work will be conducted or carried out by the employees. And another aspect would be the control as to the output of the work. In the exercise of this control, the employer may not be directly wielding the power. Thus, the normal situation or the conventional way, the employer directly exercises control. Another situation would be when the employer indirectly exercises control over the conduct of the work of the employees. For instance, when the employer engages a legitimate or labor-only contracting agencies. So even we discussed that in labor standards, that even if you are a legitimate general contractor, you may be involved in labor-only contracting if you allow the principal to exercise control over the conduct of the work of the employees. Because in legitimate job contracting, the control of the principal is only on the output. Most glaring would be in labor-only contracting. In labor-only contracting, it is the principal who exercises direct control. And the principal is, for all intents and purposes, is considered the employer. So in legitimate job contracting, the principal may be indirectly exercising the power to control, using the legitimate job contractor to avoid the legal consequence. However, with that kind of situation, the principal is still considered the employer. Everything, all others, the power to pay wages, the right to hire, may not be present. But the power of control is present, then there is employer-employee relationship. In the case of the Philippine Basketball Association referees, in the case of Bernarte versus PBA, September 14, 2011, according to Supreme Court, the referees of the PBA are not employees of PBA because there is no control as to how they perform their work or their job, as to when to declare foul or any violation of the game. The Philippine Basketball Association does not exercise control. That's the case of referees. You also have the case of the sentenciador or the masyador in CAC fighting. The case of Semblante and Pilar versus Court of Appeals, August 15, 2011. According to the Supreme Court, there is no control here over the conduct of the work of the sentenciador and masyador in cockfighting as a form of gambling. You also have consultants. Atok Big Witch Company Incorporated versus Gibson, August 8, 2011. The Supreme Court said that these consultants are not employees because of the absence of control. Consultants, they're only on call. The company will just require them to go to the work premises if necessary, or even just call them. So, remember that the determination of employer-employee relationship is a question of fact. So therefore, it must be proven by evidence. HSY Marketing Limited Company versus Villas-Tiki, August 17, 2016. Since it is a question of fact, you have to prove evidence. Now, it is the burden of proof on the part of the employee to determine first the existence of employer-employee relationship. In the case of Tenazas et al. Versus Villegas Taxi Transport and Romulo Villages, April 2, 2014, you have to prove that you are an employee. So how will you prove that you are an employee? There are so many evidence or documentary evidence that you can present. First, the most common is the ID or the company ID. If there is no company ID, it doesn't mean that you cannot prove that you are an employee. There are other documents that you can present. Other documents would be the mandatory deductions, required by the government and remitted by the employer to SSS, PhilHealth, Pag-ibig Fund. Because if this employer deducts the Pag-ibig Fund, SSS, and PhilHealth contribution from the employee, it will give rise to the presumption that the employer deducting here is the employer of the employees. So, assuming that the employer is not paying SSS, PhilHealth, or not even deducting income tax, what are other documents that you can show or prove the existence of employer-employee relationship? You also have show cause orders or notices coming from the employer given to the employee. This will show that there is employer-employee relationship. There can be no employer who will send a notice to the employee asking the employee to explain why he or she should not be disciplined. Then you also have other evidences like insurance policy taken by the employer, or the medical or death benefit of the employees can be used as proof. However, in the absence of everything or all those mentioned, then you will just make the employee execute an affidavit. Then notarize, and that affidavit that the employee will attest under oath the fact of employment. So with that, you can prove that there is an employer-employee relationship using the standard that it is a question of fact. So you can present documentary evidence. So once you determine the existence of employer-employee relationship, therefore, if there is any labor dispute between the parties, then the case will be filed before the labor arbiter. In the absence of employer-employee relationship, then other laws will apply. It may be the civil code if the relationship is contractual in nature. So if that is the case, you file it in the appropriate regional trial court or municipal trial court which has jurisdiction over the case.